Welcome back to Sustained Overruled. I am, the saying. Anyway, so today I decided to come up here. It's actually evening, okay? I decided to come up here so we can talk a little bit about the hearing that occurred in New York City on, I think it was Friday. On Friday, okay? Let me just share my screen. I am sharing my screen. I won't be here tomorrow, okay? I'm taking off tomorrow. I have some stuff that I need to do. But on Tuesday, we are starting a new trial, okay? A trial has already taken place, but if you've not watched the trial, I don't think a lot of people have watched that trial though. Anyways, we'll get into details later. Right now, I want to get into Luigi Mangione. I've said over and over again, listen, this is a good defense case. Again, I'm going to repeat myself. Criminal courts are not concerned with factual truth. That's not why criminal courts exist. Um, the evidence in this case is problematic for the defense, but there are a number of factors that makes this a good defense case. All right, let's get started. I watch a little bit of the press conference, and you guys know how I feel about that. I do not like it when defense attorneys address the press. Don't be talking too much. But I kind of figured when when Karen Freeman Agnifilo um, got in front of the press, I had concerns, okay, because previously I had mentioned how I liked her approach because she did not really talk to the press. But as she was talking, I thought, okay, I suppose if you are being paid from a $300,000 legal fund, it makes sense for you to address the people that can kind of ensure that you get paid. Let's get into it though. One moment. One moment. I'm gonna keep the comments on because I'm always curious to find out what folks are talking about.
Luigi, thanks everybody for being here today. My name is Karen Friedman Agnifilo, and I'm here with Jacob Kaplan and the rest of Luigi Mangione's legal team. My intention was not to give a press conference, not to give remarks, and not to speak outside of court, because I
Okay.
think the most important thing is to speak in court on the record. But since video cameras, the application for a video of today's proceeding was denied, I thought I would give the remarks that I gave
I
in
wonder. I'll have to look up. I'll look up the motion. Hold on.
court out here so that the people who are interested in
What's
hearing what's
up,
happening to
Brooklyn?
Luigi Mangione can hear what's happening to Luigi Mangione. So I'm going to do my best to stick to the remarks that were given in court. First, I want to start by
Oh my goodness, the comments are awful.
talking about the fact that Luigi Mangione remains in federal custody, where he is being prosecuted in 3 jurisdictions by the federal government, by New York State, and by Altoona, Pennsylvania. But he's being held in federal custody, and the Department of Justice has refused to allow him
This is as
to
much
be
as I
in
watched on
state
Friday.
custody, despite the fact that they've all
I know Brooklyn. Do you know is Karen Friedman Agnifilo? Is she Diddy's attorney as well? That's what somebody's saying. I'm not into that Diddy stuff, so
agreed
I'm
that the
probably
state
not going to
court
keep up with
is
that.
going to go first. Now, this is problematic for several reasons. Number one, the federal government is still considering whether to execute Luigi
Hmm.
and considering whether to seek the death penalty. So we are fighting that simultaneously while going first here in state court. And it impacts our ability to meet with him before court,
Okay, got it.
after
Thank
court.
you.
He's constantly surrounded by law enforcement. He's in shackles. He was wearing a vest today. Some looked like I don't even know what it looked like, but a very serious vest with his legs shackled and his arms shackled. And so he's being treated differently because he's being held in federal custody than any other person who would be facing serious murder one charges in New York State court. And I made a record in court today
Okay.
that I don't understand what this show of danger is for. When I go visit Luigi at MDC in Brooklyn, I sit with him. He is unshackled. He walks around freely in the visiting area. We sit in a room together without law enforcement hovering over us. But for whatever reason, here, despite all the law enforcement, they need him to be wearing this vest. They need him to be shackled, and they stand right over us, and we get no time with him. So he is being treated differently because of this unusual and frankly just the fact that he's being prosecuted by 3 jurisdictions for one event. It all is about one thing, one single
Okay. Okay. I'm gonna let me reserve my comments. Let me reserve my comments.
event. So we object to that. We also
Okay, I do not necessarily know what she means by objecting to Luigi being tried in 3 different jurisdictions. I'm pretty sure Karen Friedman Agnifilo is well aware that all 3 jurisdictions pretty much can try him. So I don't know what she means by objecting to him being tried in 3 different jurisdictions. It's kind of standard.
made a record today that there, although the Manhattan
I
DA
mean, it's not always that 3 different jurisdictions decide to prosecute a defendant for the same conduct, but it's not unconstitutional.
office has been providing discovery. We're past the discovery deadline, but they have made an effort to provide discovery, and we appreciate it. But what we haven't received is the police paperwork from New York City. We haven't received any of, they call them DD5s. Those are the follow-up police reports that detectives write. I am sure there will be hundreds of them, and we have not received those yet. Very important. We've also just today received the discovery regarding the arrest in the Altoona case, and we've received a little of that previously, and we are concerned that Luigi's constitutional rights were violated in Pennsylvania, and there are serious search and seizure issues.
Yeah, and the whole Pennsylvania extradition, when they're fighting extradition, that did not quite make sense to me. And the reason why it didn't make sense because under those circumstances, you'd actually want your client or the criminal defendant to be in the same jurisdiction as the attorney that would be representing them. At least from my perspective, it made sense for him to waive extradition quickly, get in contact with his criminal defense team and they can start investigating. Because the trial itself probably will not go to, I don't even see this case. What year is this? 2025? I don't even see this case going to trial in 26 um unless they pretty much cleared way for him to go to trial. But yeah, the whatever they were doing in Pennsylvania, that did not make any sense to me.
Will be litigated in that case in Pennsylvania and in this case here and in the federal case because it is alleged that Luigi had a gun on him and had other property on him that they are going to use against.
I understand what you're saying, Brooklyn, but I think I don't know. From what I've heard, okay, I've not been incarcerated, but from what I heard, folks do tend to. I mean, I know enough about Rikers, but folks do tend to what is this? Prefer? I don't know that anybody would prefer incarceration, but folks do make arguments that federal incarceration is slightly better than state incarceration. I mean, Rikers is a completely different animal.
Against him in all of the cases, and if there is a search and seizure issue, and again, we have to review all of the paperwork and camera footage when we receive it before we say definitively whether we think there is one. But so far, what we are seeing is we think there is a serious search and seizure issue, and so we want the opportunity to litigate it, including in Pennsylvania, where he was supposed to have a court date on February 24th, but the Department of Justice is refusing to transport him and allow him to face the charges in Pennsylvania. So he cannot
That's a little
litigate
odd.
those issues in Pennsylvania. And which brings me to the most important point that we made today, which is Luigi's right to a fair trial is being infringed upon because he is being publicly treated as guilty and
Right.
as having the presumption of guilt as opposed to the presumption of
Right.
innocence, which is what he is entitled to. And although, of course, I understand.
Okay, so that point I do agree with Karen. What's her name? That's such a long name. Karen Friedman Agnifilo. I agree with her from the perspective of, I guess these perp walks that they've been doing with Luigi. That is a little troubling. Brooklyn says MDC is better than Riker. She's trying to drag Eric Adams into this. How is she trying to do that? And I mean, Eric Adams' case is apparently going to move forward, at least for now. That's what the judge said.
Understand the NYPD's need for
Yeah, Brooklyn, I want you to explain what you mean by Karen dragging, what's his name? Eric Adams.
press conference before an arrest or after an arrest, which they did here. I didn't like it, but they did it, and I
What
understood
did
it.
you say?
Of course, I understand the NYPD's need for a press conference before an arrest or after an arrest, which they did here. I didn't like it, but they did it, and I understood it. What I did not understand was how shocking it was that this week on HBO, in a documentary, I see the chief of detectives and
What,
the
they have a documentary out already? These folks are not
New
playing.
York City mayor, full hair and makeup done, sitting down and giving an interview for television and talking about the evidence in Luigi's case, talking about police paperwork that we don't have, talking
Okay.
about forensics that we have not yet received. I guess we have now today, but I didn't when I was sitting there learning about the case, hearing an actor play Luigi reading from a journal that they say is
Okay, hold on. Wait. Okay, let me just, I'll reserve.
Luigi's, and we have yet to receive it from the prosecution. And so it's outrageous that they have
Okay.
time to go and prejudice Mr. Mangione's ability to receive a fair trial and go out and make these statements, but not give this to us. And so we are concerned because if the chief of detectives is telling everybody about all this evidence,
Right.
and what if it ultimately gets suppressed because it was an illegal search and seizure in Altoona, Pennsylvania? How is he going to get a fair trial? So those are a little bit more than I was allowed to say in court, but that's the gist of it. That's what my prepared remarks were, and hopefully will allow cameras in the court going forward. If not, I will.
I've been trying to think, I don't know. I'm trying to think of, okay, I guess that might be the norm. I was trying to think about whether I was trying to think about other cases where cameras were allowed in New York City courts. And from what I can remember, it is not out of the ordinary to actually have the press actually recording the proceedings. I mean, the feds, that's something different, but I was just trying to think of individual cases where it was allowed.
Continue to provide information. We put up a website that just has basic information. It's luigimangioneinfo.com, and we will post
Wait,
a
what?
transcript of today's proceeding
Okay, let's go.
on that
What is
website.
it called? Luigi Mangione. Did she say information? I don't know. Let's go back. They have a website and
Not,
everything.
I will continue to provide
Oh,
information. We put up a website that just has basic information. It's luigimangioneinfo.com, and we will post a transcript of today's proceeding on that website. And that's where we are going to be providing hopefully accurate
dang.
information about this case. I apologize. I'm not going to take any questions, and I'm not going to make any other out of court statements because this is truly intended just to be a recitation of what happened in court. But one
Okay,
last
so
thing is
Karen is still my kind of attorney. Okay, I don't really want you talking to the press. prior to a verdict.
Luigi really wanted to thank the supporters for being here, and we all appreciate it very much. Thank you so much.
It's a little odd. The fact that they have a website, I guess this is different. Brooklyn says that they hired a PR firm. I suppose it's just, I guess it would make sense, right? It would make sense that his legal team would hire a public relations firm. As far as this website, I don't know. This is 2025 stuff. Um, I don't know. It's a little. I don't know what I make of the website, but I am on the website. At least on my phone. It's. I don't know. I don't know what to make of this. And then they have case updates. So Pennsylvania, his court date is Monday, tomorrow, I believe. So 224. They give you the location. They don't have a time. And then on Wednesday, March 19th, he returns to New York City. And then Thursday, June 26th, New York again. Oh, okay. So listen. So March, it's actually the federal government. March, federal government, and then in June, it's New York State. All right. I wanted to see. Hold on, I'm trying to find them. Oh, sealed. Never mind. I was trying to find. I was trying to find. I was trying to find paperwork in Luigi's case, but some of these are sealed. I don't have time. I don't even know that I have authority to look at this stuff. But hold on. There's something here. Let's see. Let us see. I'll figure it out. Tomorrow I'm taking off, okay? Tomorrow I'm taking off. The reason why I'm taking off is because I have a CLE. Hold on. I have a federal CLE. I don't know if it's tomorrow or the day after. I think it's Tuesday though. Oh, hold on. Just a moment. Sentencing. I have a CLE one of these days. Okay, never mind. It's on Tuesday, the 25th. Um, in any event, tomorrow I'm taking off so I can clean up a little bit of this YouTube. Okay. And I'm trying to figure out how to post articles on here, how to share not really articles, core documents without leaking my actual email, my personal email. All right. I think I may have found a way around it, but I'm not sure. I have to test it out tomorrow. But let's see. What do we have here? I don't know. It's too tiny on my phone. You guys know I have astigmatism, so I cannot really. But as far as I don't know, the website is a little odd. It's a little odd. It's a little odd for me. And then Brooklyn, when is I'm getting my dates mixed up. Hold on. I'm getting my dates mixed up. I watch a little bit of, not a bit. I watched a lot of the Karen Reed hearing. Okay, watch the Karen Reed hearing. Bev was on about something. I know what Bev was on about, but she was on about something. And the from what I recall, she said, "Let me get my thoughts together." I know she was shaking and exaggerating. Let me not say that. Maybe she was really just shaking. Maybe it's something else. But I want to find the actual hearing because I thought the Luigi Mangione here press would be much longer, but it was not. Okay. So let's see.
Good morning, Your Honor. Laura McLaughlin for the Commonwealth. Good morning, Ms. McLaughlin.
Adam Lyle for the Commonwealth. Good morning.
Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan.
Okay, so Brooklyn said Tuesday is Karen Reed. Oh no, bueno, that's gonna mess with my schedule. Let me think about it. Yeah, that's gonna. I mean, I'm off. I'm not working this week, but I wanted to start. Want to start a new trial. So let me think about it. The trial has already happened. I do not know that a lot of people have actually watched the trial, but it's a good trial because the trial itself highlights this distinction between factual truth and substantive truth. And I thought it's an educational trial to actually watch, right? So I didn't. Yeah, I am gonna watch. That's what I'm gonna be live streaming. I'll be live streaming that trial because I'm kind of torn. I'm like, okay, do I live stream a trial that has already occurred, or do I just summarize? Do I just summarize why it makes for a good trial? I'm not sure. Let me think.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson from the street.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Morning, Your Honor. Robert Alessi from Miss Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Unetti for Karen Reed.
Good morning, Mr. Yannetti. Good morning, Ms. Reed. All right, I was told counsel
And
wanted
that girl Reed did not even say anything to the judge.
to see that sidebar.
Briefly, Judge.
I don't have time for that.
All right, so
What's up, Jason?
what I'd like to do is start with, now I don't know if you all have the paper numbers on these. You probably do if you've been looking at mass court. So Commonwealth's motion for records, WFXT TV, Boston 25. This is paper 479. Mr. Brennan?
And Brooklyn, what do you make of the prosecutor in this case? Do you? I guess I mean, you're a Karen Reed supporter, so maybe you don't like him.
Good morning again, Your Honor.
Morning.
I spoke to Mr. Albano last week and
Albano,
again
Albano.
last night,
Okay.
and on behalf of Fox, Boston 25, they're agreeing to my motion in its entirety. They've asked for the courtesy if I could wait until March 1st to
What do you mean
receive
by
all of the
agreeing?
information. I expect they'll file it with the court.
Okay.
And so with the court's permission, I would ask Your Honor to endorse that agreement. Attorney Albano expresses his regret he couldn't be here. He had another engagement.
Okay. All right, I will. So March 1st before they can get it here? Was that the
Yes, they
date you
they'll
said?
have it on or before March 1st.
Okay. All right, so that motion is allowed by agreement and the order is right here, Mr. Clerk. All right.
All right, come on, get into it.
Next, I did amend the scheduling order, so we don't need to hear that anymore, right? And I tried to do it, Ms. Little, to save you from working an entire weekend. You got it early enough to do that, right? On the 10th of February?
Yes, Your Honor.
Okay. All right. So paper number 483. This is the motion to compel production of a forensically signed copy of the January 29, 2020 video surveillance footage and law enforcement.
Oh, by the way, I tried to watch part of the juror interview, the Karen Reed juror interview. Okay. I did not watch it in its entirety, but the comments, what I gained from that, or what I gleaned from it, was that the juror was of the opinion that Karen Reed was guilty, and obviously it sounds like the viewers were in disagreement. If I remember correctly, I don't remember on whose channel it was, but the channel had I don't know, it had a serious intro. Let me leave it alone.
Custody and the opposition. Jim, I don't have a docket number on this. I think it was just filed. The Commonwealth's opposition in response. Do you have a paper number? Okay.
Right,
Compelling.
take forever.
Choice.
Come on.
Thank you, Your Honor. My comments will be relatively.
There we
brief.
go,
We filed this
Turtle
motion
Boy.
Basically, because we had no
And
choice.
isn't Turtle Boy the individual that had issues with the court? I think they were barred during the first trial, something along those lines.
We were following the court's instructions, meeting with Mr. Brennan after court, the last hearing, which was the 6th, about the download of the video footage that apparently has been stored, or at least we believed at the time last week, had been stored on some sort of an iCloud. We were told that this was an account of a retired detective, as explained by Mr. Brennan. We met after court. Mr. Brennan told us that we did not need, we told Mr. Brennan that we did not need an expert to fly out and go through all the machinations of having someone present if all the information was a download from some iCloud account, unnamed iCloud account. As long as that was videotaped, we were fine with it. And that was basically the agreement. That was the information that we had at the time. We were predicating that on a conversation that we had with Mr. Brennan in January, I think it was January 22nd. He indicated that he went to Canton PD the same date, and the court will recall December 12th was the date of what I've referred to as sort of the wild goose chase, that we sent an expert out, etc. That same afternoon, apparently Mr. Brennan went to the Canton Police Department and found out that there was, in fact, additional video, which was news to us. He claims that it was news to him.
Sheesh.
And putting aside how odd that is, after 3 years of being told we have everything, he went on to explain in very specific form in a telephone conversation.
I'm going to skip forward a little bit.
A retired detective. At the time, he could not remember the detective's name. He said that the detective believed that he kept a copy of the January 29 video that we were looking for, and that he said that it was on a work computer's iCloud account. Mr. Brennan said that they intended to download it from the iCloud, turn it over, and that's the point at which we said, if you don't mind, just hold on that, because we're litigating ultimately this issue, which was the litigation we had on February 6th. So we had the
Well, I'm going to skip forward.
The day after court on the 6th, after we reached this agreement that the iCloud would just be downloaded and videoed, we received an email from Ms. McLaughlin, and that changed the parameters of what we had believed and what we'd been told by Mr. Brennan. And it sounded more like this.
What's
the Commonwealth
up, Benji?
changed the story from some work computer iCloud account to
What's up, Jerome?
the footage was being stored on what's called the, quote, department's video file system.
Jerome, did you win any money or no?
Very different than a retired
Benji, are you working today or are you off?
officers or retired detectives' work computer's iCloud, which is what Mr. Brennan believed is video file system. It's very different than a retired officers or retired detectives' work computer's iCloud, which is what Mr. Brennan believed at the time and what we were led to believe at the time.
Oh.
So we asked for clarification. Ms. Little sent an email saying, I'm confused. Now you're talking about something that looks like a much more formal system called the department's, the CPD video file system. So we want, that's fine, no problem, download the videos, but we want the metadata and the log files that are associated with that. If it's on a formal file system, it's going to have metadata for the upload, for any access to the data, and for the download. We want the metadata and the log files as well. And that's the key entirely to the audit trail that we're interested in. Historically, we have been asking for videos, for all this video surveillance to be preserved and provided for about 3 years. And this has been one of the centerpieces of this litigation. When we asked for that additional metadata and the log files, Mr. Brennan, in my opinion, took an odd position, which is, nope, we had an agreement.
I know, I noticed that too.
You said that you could videotape the download of the videos. You don't get anything else. If you want anything else, go to court and file a motion, which is why we had to file this motion. We don't think that it was necessary. This is metadata that is literally in the Commonwealth's possession as we speak. They have it. We're entitled to it. It's simple. That's all we're asking for. Mr. Brennan referred to the video files being placed on Canton Police Department detective file, which is yet another name for where this mysterious video may be held. And we said, it's easy to get the metadata. Let's just do a quick forensic image. It'll take less than a day. And all we want is the metadata for the 24-hour period, 23 hours and 59 minutes to be exact. And we don't need to file the motion. The first question I have is, why would the Commonwealth even object to this? It doesn't seem like something that they would want to object to. This is in their possession. They know that they've got it or they've got access to it.
I'm sorry, Jerome. Sheesh, I'm sorry. I'm sorry. I'm sorry. Have a safe trip back home. Benji says he's at work. Okay, gets out in an hour and a half and going to eat at Applebee's. All right, Benji. Good for you. Good for you. All right, Jerome, have fun. Have fun. I think you're somewhere. I think you're somewhere in Louisiana. Or maybe, I don't know. Did you maybe go to Gulfport? I don't know. But yeah, have fun.
Why wouldn't we get it? These videos, again, have been a pain point for this case. These videos have been a pain point for this case for time immemorial, since the beginning of the case. We've been demanding that footage from 2022, January 29th, 2022. We were told explicitly on December 12th that
I
no
want to fast
footage
forward just
existed
a
when we
little
went
bit.
out and had an.
I've watched
Thank
the
you, Your Honor.
majority.
Okay, the next one's paper.
May I be heard briefly?
Yes,
May I be heard briefly?
yes. So I did just say unless there was an opposition. Is this an opposition?
It's not an opposition, but I have some thoughts that I want to share with the court.
Okay.
It's not an opposition because I think a defendant who's presumed innocent has the right to counsel of their choosing.
Okay.
I think it's a very fundamental right. And I don't think the Commonwealth should dabble in taking a position trying to prevent an accused from having counsel of their choice. That being said, as Your Honor may be aware, Mr. Betterow is also.
I figured, Jerome, I used to live over there, okay? I'm very familiar with the area. If you say that you're not going gambling in New Orleans, it made sense that you'd actually be going to a Gulfport, all right? So, yeah, I figured it has to be in that area. It sucks. It sucks that you did not get to win, but hopefully you had some good food, okay?
An attorney for Mr. Kearney. And that is something that I think the court should consider and be thoughtful about for a couple of reasons. There is a history, a symbiotic relationship between Ms. Reed and Mr. Kearney. There is a history of
And who?
reasons. There is a history, a symbiotic relationship between Ms. Reed and Mr. Kearney. There is a history of documented evidence showing the sharing of discovery between the parties.
Okay.
And inevitably, that discovery is promoted in such a way that abuses, harasses, and bullies witnesses in this case.
Sheesh.
Not unmindful that there's over a dozen indictments against Mr. Kearney, which Mr. Betterow is representing him for. Now, it's not great clarity, but it's been represented that there is a relationship between Mr. Betterow, Mr. Bradel, who's Mr. Kearney's other attorney, and the defense attorneys in this case. There's a record that has been represented that the attorneys in Mr. Kearney's case, Mr. Betterow, Mr. Bradel, have an understanding with the defense attorneys in this case, that there's an ongoing long-term implicit mutual assistance and mutual defense.
All right, Jerome. Enjoy the rest of your trip, and we'll connect. We'll connect when you return, okay? And have a safe trip back home.
Commonwealth is not entitled to any product of a mutual defense, but it is curious in that Ms. Reed and Mr. Kearney are not co-defendants. It is curious that given the indictments, most of them that deal with witnesses in this case that allegedly have been harassed and intimidated, it is curious that that relationship exists and the nature of that relationship. It's not something that I think I'm entitled to, but the court certainly could delve into that ex parte. It's important because we'll later talk about, in a sanctions motion, a violation, a direct violation of protective orders in this case. And the discovery in this case was provided to special attorney in Mr. Kearney's case to make sure that there was a thorough review of all discovery, and much of that was turned over subject to a protective order.
This is crazy. I see that Core TV interviewed Turtle Boy over a year ago.
I expect there'll be a similar motion in Mr. Kearney's case. Within 24 hours of the violation in this case, there was a violation of different material in that case. And so inevitably, you have Attorney Betterow who will be serving two masters. He will receive protected information in this case that is supposed to remain protected and not leaked and distributed to the media and the press and court pleadings. And some of that information will not be information that Mr. Kearney is entitled to.
Okay, so Brooklyn is saying that who's this? Turtle Boy's attorney wants to represent Karen Reed as well. Why? Does he not have enough clients?
And being in a position of representing two different defendants.
Is it trying to make a name for himself? I don't know. That doesn't make sense to me, but what do I know?
Who are not co-defendants, being in that position is going to be a difficult task to manage. And I am worried, and I have good reason to be worried about the privacy of our protected material. I have good reason to be concerned about the improper dissemination of our material. I have a reason to be concerned about the continued harassment and bullying.
What do you make of Brennan, Brooklyn? Do you like him? Do you not like him? Are you indifferent?
Of witnesses and this information, if a court order won't protect it, then nothing will. And so we know this relationship is substantive. We know it is a deep relationship. The attorneys, in fact, in this case, have direct communications or had with Mr. Kearney, over 29 calls each.
Sheesh.
And so, not to speculate, but having a mutual agreement, a mutual aid agreement, does not allow an attorney then to become one of the attorneys who is entitled to protection under a protective order in a particular case.
What do you mean by bumped off?
Doesn't. And that concerns the government. And so while I do not object to Attorney Betterow.
And who are they? They that are afraid, who are you referring to? The
As
Commonwealth?
many lawyers as they want. I think the court should have some caution and some concern and should consider some type of inquiry ex parte without the Commonwealth present about the nature of this joint aid agreement and the history of it and whether protected information was ever shared prior to Mr. Betterow presumably joining this case. And whether there's protocol in place that if there is protected information in this case, that it does not leak again. It does not get shared with a non-co-defendant. I don't even know how to describe the relationship. I'm asking the court to consider assuring itself of those safety measures because this trial is going to happen.
I know. I had to look up Turtle Boy because my last what is this? What is this? Hold on, let me get it together. During the Karen Reed trial, that's when I was introduced to Turtle Boy, but you guys know I don't have real social media apart from YouTube and Reddit. Okay. So I had to look up what's going on with Turtle Boy. Okay. So again, this is what the internet's saying. So he was arrested and jailed on charges of assaulting his ex-girlfriend. And then he was released in February of 2024 after spending about 2 months in jail. Why did he spend so much time in jail? And then let's see. So he's considered a controversial blogger. Okay. This is just, I don't know what they have going on. They have something going on. What did Brooklyn say? He's not licensed to practice in Boston, only California. I mean the defense. Oh, I get it. So Brooklyn, you're saying that defense is worried that Alan Jackson will be excluded from the trial. Okay, got it. Yeah, I mean, but he's appearing pro hack Vici. I've done that before.
And these witnesses should be able to walk into this courtroom without fear, without bullying, without abuse. And that has not happened. For many reasons, it has not happened. And this makes it a more complicated issue. The defendant is entitled to a fair trial, which means she's entitled to another attorney. So I don't object. But the Commonwealth is entitled to. The Commonwealth is entitled to a fair trial. And the witnesses are entitled to walk in this courtroom without being abused.
Okay.
Thank you.
Okay.
Those poor old people.
Ms. Giannetti, I have to consider everything that was just said, but I'll wait for your affidavit.
Right. We'll try to address those issues in the affidavit, Judge. Thank you.
Okay. All right, the next one, I believe, is paper 489, Commonwealth's motion to amend the December 5th order pertaining to audio recordings in possession of.
All right, let's
Captain
quickly move
Rossi and
forward.
Elementary Court.
Hold on.
Relatively straightforward, but I'll hear you, Mr. Brennan.
Your Honor, you provided us the full audio between the defendant attorneys and Ms. Voss. I'd like to have it transcribed because I expect to use many parts of it for trial. The order was all the attorneys could listen to it. I can report none of the attorneys have listened to it other than me. It was sent to a transcriber, but I told the transcriber not to listen to it or record it because although I expect it might have been in the protective order, I want to be beyond caution on this and beyond reproach.
Hold on, I want to move
To
closer.
be able to make a copy, stenographer make a copy so that we can identify pieces that we expect to use for trial.
Okay, there's no objection to this, is there?
No, Your Honor.
I want to move closer to Bev, actually.
All right.
I want to move.
So the Commonwealth just provided the court with information that causes me.
Okay, I watched this. I need to go back to. I want to go back to Brennan and see what caused Bev great concern. Okay.
We provided all of our materials
I cannot actually
for
see.
all of our experts. Good faith terms and words that there is no.
And the reason it's interesting that they're objecting to this request is because
What's
our
this
discovery
part?
request is copied verbatim from Attorney Brennan's request as to the ARCA experts. Now that he's on the receiving end of that request, he's objecting to it. All we're asking for are the material and relevant communications that the Commonwealth and its agents
I know
have had
Justin doesn't look
with
too
their
good.
experts in preparation for this case. Ms. Reed is entitled to that, and it's proper in terms of being able to effectively cross-examine those experts. And as to request 10, Your Honor, there's no objection. We'd ask.
Well, that sounds like the prosecution was so good they had to copy. They had to copy the emotions.
Be allowed.
Okay.
Thank you.
All right, Mr. Brennan.
I listened to part of this, but I was at work and I was listening to it, so I could not get
It's
the
important to represent facts accurately.
Sheesh.
And the court has ordered in the past when representations have been made that they be accurate.
I don't know. I like Brandon. Okay, I like his style of lawyering. He appears sharp. I mean, I've not seen him at trial just yet, but I do like his style, and he likes to insult people. Apparently,
We hear an echoing of a claim of Brady, but we hear no substance behind that claim from the defense as to.
listen to that. Like this man could write judgments, actual criminal court judgments. Okay, and I'd read them because his use of language is immaculate. Chef's kiss. Let's see. He said what?
It's important to represent facts accurately. And the court has ordered in the past when representations have been made that they be accurate. We hear an echoing of a claim of Brady, but we hear no substance behind that claim from the defense as to, number one, the Commonwealth is not going to make logs up that don't exist. They're not going to make a record of something that is not in writing that there is no witness for. The defense has asked the chain of custody, logs, evidence, reports. If they existed, they would get them. I told the defense in an informal discovery request I would look into any chain of custody information.
Okay.
And I did. I've spoken to a number of witnesses, including the retired sergeant, and I expect that I will have him write a report to give to the defense, and I'll provide them all the information that I have about what I could find out about the tapes that were provided in this case, where they came from, who downloaded them, who touched them, and who they went to. But there are some things the Commonwealth cannot do. They cannot simply invent a log when a log does not exist, and they cannot invent a chain of custody that is not in writing and there is no witness to. I've done my best to be thorough and diligent, and they will receive a report and have all the information that we have. It's odd that it's important during argument to mention that there's.
I know I'll be up here until about 8 p.m. Then I need to go because I need to feed my daughter. But I'm on the fence. Brooklyn, Benji, if you're still in here, let me know if you want to jump to Turtle Boy a little bit. Because again, I've watched the majority of this hearing. Okay, I've watched most of it. I've watched it probably over and over again.
Ongoing federal investigation, and then list a number of witnesses.
I was trying to see if I missed anything.
Implying somehow something's nefarious, that these witnesses are involved in this other controversial case that has nothing to do with this case that the defense would like to parasite onto.
I don't know. I think this is Karen Reed's mother, so she looked like she chuckled a little bit.
Implying somehow something's nefarious, that these witnesses are involved in this other controversial case that has nothing to do with this case that the defense would like to parasite
You know, something
onto.
tickled her.
And so they just throw out terms and words for our audience that's here on our right to try to create an illusion of impropriety.
Sheesh.
There is nothing that they have provided about the Birchmore case that will provide a basis for the Commonwealth to now go scramble and search for information that there's no good faith actually exists. It's easy to throw out a name and attach it to the Birchmore case. Troopers, the DA, malign their name the way they know how to do. But when you're arguing a discovery motion, there must be a factual basis for it.
Dang, the
A factual
insults.
basis, a good faith basis. We hear the defense say that Trooper Guarino says, nothing to see here. I have not seen that report where Trooper Guarino says nothing to see here. I don't know what report they're speaking about when they suggest Trooper Guarino had done something wrong in a different case. They imply it. They're suggesting that's the basis for you to compel discovery on a case that has nothing to do with Miss Reed's case. They just say it. And so you should reject outright an argument that tries to imply impropriety when there is none, with no factual basis or good faith basis, because they want to entertain our audience.
Sheesh.
And so the reality is the Birchmore case is being investigated by federal authorities. There's been a number of disclosures by the Commonwealth for information that has been public record. And there is no good faith basis that there is something in that case that is relevant in any way to this case. Ms. Birchmore was a victim. Number 4, unredacted copy of all reports, communication, handwritten law enforcement notes, again, in the Birchmore case. Why? Why that case? Troopers work on many cases. That case certainly has a public appeal to it.
Okay.
Because of the harshness of it, the sadness of it. But what does it have to do with this case? Nothing. But invoking it is helpful for the defense. So they do. You should reject it outright, Your Honor. Number 5, all communications, documents, reports, memorandum regarding Trooper Proctor administrative proceedings.
Yeah, I don't know how they get around Proctor.
Any
I have
information
no
in
idea how they
Commonwealth's
do that.
Possession and control, we would and we do turn over. In addition to what's in our possession and control, we know that there's likely statements that would be helpful for the defense. So we have an affirmative obligation under Graham. In fact, I had a conversation with defense counsel, and they asked if I would join them in a phone call and speak to counsel for the state police to try to encourage the production of materials in this case, whether they're exculpatory or not, even material irrelevant. And I agreed I would do that upon request. Now, that call has not been set up by the defense, but when it is, if it is, I will be there and I'll advocate for them for this information.
Okay.
In addition, there's a Rule 17 that has been ordered by this court that imposes an ongoing duty separately upon the state police. Now, state police have certain protection where it's an internal affair investigation by law. I cannot usurp that law. I can only earnestly try to my best of my ability. I sent an email on January 28, 2025 to a number of attorneys at the state police. And I informed counsel in view of the Commonwealth's responsibilities under Brady versus Maryland in Giglio, and most recently set out in McFarland and Graham, the Norfolk District Attorney's Office is inquiring whether the Mass State Police Legal Department and law enforcement officers assigned to the
He's
state
taking
police general
forever. I'm
headquarters
gonna
in
move
possession of any
closer to
relevant
Bev.
material, statements of Mr. Michael Proctor, witness statements, and any findings relative to the department investigation and hearings relative to this.
Yeah,
They,
I still don't know how the prosecution gets over Proctor, because Proctor is very problematic.
the Commonwealth, are going to argue, I didn't personally inspect the vehicle. I had enough information from the material I reviewed, so it wasn't necessary. Need to show the jury it doesn't matter in this case.
What's the date of that?
Oh, this is the substance. Hold on. I need to go back a little bit.
So please feel free to make whatever changes you.
Yeah. I don't know. This was very problematic. It was you guys, I've mentioned it before. I don't text. I don't like to text. I don't like to put anything in writing unless I actually want to keep a record of it. But this was problematic for the defense.
Conversation till we receive.
Hold on.
Where of any taking the time to get on the.
Yeah,
that
this
there are
was
conversations between the defense.
All this stuff is problematic.
Some familiarity with the federal government. 12 and 28/13 of June 10, 2012.
Who's the drama queen, Brooklyn?
Now, having some familiarity with the federal government.
Or are you talking about Bev?
It seemed to me, based on my limited experience, there was much more to the story. So I called the federal government and I tried to encourage them to provide full discovery so that the experts could testify. I was resigned to a TUI letter. I've been down that road many times. It's a dark road that never sees the light of day.
He uses way too many words.
TUI letter. And it was delayed. And over a long period of time with requests and deadlines, I finally received a response that was unresponsive. And it was striking that it wasn't noted as unresponsive. Just when I read the materials, and Attorney McLaughlin actually identified them, they didn't respond to our request. So Attorney McLaughlin wrote back, and then we got new materials, just some. But these materials are the very reason why the defense should not be able to call witnesses without giving full discovery.
Okay.
Having not been at the last trial and reading the transcripts, I only have a flavor for the last trial. So there is email correspondence between the defense, not only the federal government, but the ARCA witnesses themselves.
Oh, no, that's
recent request
it's a rookie move.
Their appearance pursuant to TUI, which I have no issue with. But if we look back earlier in the relationship, what we see back in March 22nd, 2024, is that there are conversations between the defense, Attorney Jackson.
I'm trying to figure out how the defense is reacting. He's the only one writing. Everybody else is somewhat stoic.
Who's one of these ARCA witnesses. Thank you so much for taking the time to get on the phone with me this morning pursuant to our conversation. Please feel free to forward an engagement letter to this email address. I will get that countersigned and return to you forthwith along with your retainer as required. Commonwealth, as I understand it, was not aware of any promised rewards or inducements or payment. They relied on a reciprocal discovery order of this court for that information. Response, hi, Alan. Subsequent to our conversation on Wednesday, the U.S. Attorney's Office.
Brooklyn, did they want to respond?
As we pause any further conversation till we receive
So the way that I understood the defense was going to respond in writing, and that's the purpose of the next hearing. I thought that was the purpose of the next hearing.
Information from their office.
I do not know that Bev, I mean, it's not impossible, but I would be very surprised if she made a decision without hearing defense out first.
regarding how our involvement will move forward. Now, it's not the opinion that troubles me, it's the relationship, and Commonwealth should have an even playing field. Saturday, June 22nd, Daniel Wolf writes, Alan, I spent some time this morning putting together a brief outline of my qualifications, also attached my D&T list. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, so please feel free to make whatever changes you feel necessary.
Yeah.
Now, this isn't information provided by the defense in reciprocal discovery. This is information provided by the federal government after numerous requests, 2 requests, and
I don't know. They're freaking out a little bit over here.
the best I can to get as much information as I can. We then are provided an outline of questions and answers for a direct examination. The Commonwealth did
And
not
I've said this before. I'll keep saying it over and over again. Just turn over everything. Do it. Turn over
have the
everything.
luxury to privilege, did not even know that there was an outline that was being disseminated by this totally independent witness who took no side other than that of the truth. What follows
Yes.
from this outline is then the outline with remarks from this independent expert who knows nobody. So we see in the margins in the notes, this fair-minded objective witness says,
All right, I'm just trying to get through this and then moving over to Turtle Boy just a little bit.
so not being able to inspect the vehicle is something that's not uncommon in your line of work. And he writes, absolutely not. And then he comments, not sure if you want to put this somewhere in the direct examination. I have a feeling they, the Commonwealth, are going to argue I didn't personally inspect the vehicle. I had enough information from the material I reviewed, so it wasn't necessary. Need to show the jury it doesn't matter in this case.
The date of that?
It's not dated. It's not dated. The TUI request is a recent February response, but they send random documents. There's no real accounting. Now, I'm not saying that undermines the conclusions of ARCA.
Okay.
I'm not saying they're not qualified witnesses.
So what are
It
you
certainly
saying?
shows some bias. I've turned over a lot less in this case than this. Another comment. Would be fair to say because you had a lot of nighttime visibility work, your cases frequently involve pedestrians. Yes, unfortunately, there is a direct correlation between the time of day and pedestrian fatalities. Statistically speaking, most pedestrian fatalities occur during the evening and night hours. That would have been nice to have. So my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians. Pretty important stuff in this case. And then he comments, if you don't want me to say this, that's fine. That's
It's
fine.
crazy. I do not know why for defense, I do not know why they had this in writing. I don't know why they were having this conversation in writing. It makes no sense because that's I don't know. It makes no sense that they'd actually have these conversations in writing. That's a phone call. Okay, you get on the phone and talk about it and leave it at that.
Shh. Don't tell them.
Yeah. I don't know. She seems a little pleased over here. Hold on. I'm no body language expert, but I can see a smirk when I see one.
Don't tell them.
Yeah, she's tickled.
Have you qualified as an expert in court before? Yes. I realize my testimony, I said it 20 times when you asked how many I've been qualified. I misinterpreted the question. My fault. 11 trials, 7 depositions. Not sure if you want me to clear that up. I don't know if it was ever cleared up.
Okay.
And then a bill from ARCA to the defense for $23,925.
How much money?
ARCA to the defense for $23,925.
Sheesh, all right.
That's not trample. That's not trial by ambush. That's getting duped. So
This man has way
that's getting duped.
words.
So I didn't know any of this, but I've tried a few cases. I've been around the federal court a little bit. I know how it works.
Okay.
Sometimes parties pick sides.
All right.
It creates an imbalance and unfairness, and then it allows the ability to one side to use ghosts.
Sheesh.
They create illusions and shields and say something's there and something's happening, a federal investigation and this person, and then this happens. I don't care if the ARCA witnesses testify at trial. I don't care about their opinions, but I care that it's unfair, imbalanced, and hidden. And the Commonwealth, like the defense, is entitled
Yeah, Brooklyn, I am aware. That is John's mother.
to discovery. So if they can produce the discovery, I'd welcome ARCA.
Mm.
All right, I'm going to take a recess.
Hold on. Let's see
The
how.
Commonwealth, like the defense, is entitled to discovery. So if they can produce the discovery, I'd welcome ARCA.
All right, I'm going to take a recess before we
She disappeared for an hour. And then she comes back a little shaky. Let's see. All right. Come on, babe.
All right. So the Commonwealth just provided the court with information that causes me grave concern.
Okay.
The implications of that information may have profound effects on this defense and defense counsel. So for that reason, I'm going to suspend today so that when we meet again to address these issues, all affected will be appropriately prepared.
Okay.
So I'll see you a week from today at 11 o'clock in the morning. You can tell me now if
Oh,
it
at
is
11?
impossible for you.
Kind of late.
And where Mr. Brennan, where the federal
she's
authorities
shaking.
have been kind enough in the past to allow me to have copies of everything, would you be kind enough to call over there or check with whomever you were dealing with to see if I can in fact get a copy of everything that you just read?
Who knocked the podium? Are you referring to what is this? The prosecutor, Brandon?
I can, and there's a brief chronology I think Your Honor should be aware of. If I could add that right now, it would take me less than a minute. The chronology is December 4th, we sent another tour request, 2024. January 6th, we filed our notice of intention to exclude ARCA experts.
Okay.
January 30th, 2025, the United States Attorney's Office sent a response to both ours and the defense requests. Without any prompting, on February 6, 2025, the defense and the prosecution received an email
When
from
was
the U.S.
this?
Attorney's Office saying that the contract had ended with the
18.
ARCA experts, and that if either party wanted to engage, the original materials are still protected. This was a change in position about whether a party could engage. On February 11th, we filed the motion to exclude. February 13th, the defense provided us the emails that I read. February 13th, 2025, I think I said the federal government. It was the defense. February 13th, 2025, they sent us the emails and the direct examination outline.
Okay.
We reached out to the federal government again because I was curious about the change in position on February 6th, that the contract has ended, but that parties could contact ARCA. Obviously, the Commonwealth is in no position to contact ARCA because that would naturally preclude the defense from retaining them. So we've refrained and we will not reach out to them.
All right, so the information that was provided to you, not from the federal government, I'd like a copy of before you leave the courthouse today.
Yes, Your Honor.
All right, 11 o'clock a week from today.
Your Honor, is it possible to?
Yeah, I think Bev, in not, requiring the defense to respond on the spot, that does, give them enough time to formulate a response. I do not necessarily see that as a disadvantage. I think I'd rather be prepared to explain why I did not turn over evidence as opposed to being required to respond on the spot and being locked into a response that I cannot polish up later on.
One day to the 26th instead of the 25th.
No, he does not look too good. I quickly want to go to Turtle Boy. Okay, stop sharing. I want to go to Turtle Boy a little bit. I don't know that I'm gonna play the video. Is this it? Nope. I cannot see. Maybe this is it. Is this it? I think that's it. Yep. Let's. I don't know. This intro was a lot for me. The intro was a lot for me. I cannot do that intro, so we're gonna have to skip past it. Okay, so they have little turtles out here. When I listen to this or part of it, I was at work and I was on my phone, so I could not see. I could not see the chat.
Doing
Good, thanks. How are you?
good. Thanks. Thank you for coming on. I appreciate this.
No worries.
Yes. So yeah, you were stuck behind a
Give
plow I
Turtle
heard,
Boy a like.
on your way in there. Wasn't Lucky Locker Room,
Yeah,
was
of
it?
course.
It wasn't Lucky Locker Room, was it?
Yeah, I mean,
No.
the snow, right? We're trying to
Yeah.
beat the system, right?
Well, let me start off with that, right? There's actually an interesting video that I just saw come out that somebody took driving by 34 Fairview Road. And I want to have you visited 34 Fairview Road, obviously, on like the first week of the trial, right?
That's correct.
What were your thoughts when you saw
When?
the first week? You visited 34 Fairview Road, obviously, on like the first week of the trial, right?
That's correct.
What were your thoughts when you saw 34 Fairview Road and the car parked outside, in the lawn? What did you think of the whole scene there?
It was surreal. I think it was very interesting to be able to see the atmosphere. It would have been nicer to see it in a little bit more with some snow, just to see what would that look like. But we were trying to observe the area and the environment at the time.
Well, funny you should mention that. So this is people love to do this. This is what somebody just drove by like an hour or two ago, 34 Fairview Road. And this is the perspective that 7 or 8 of the witnesses would have seen. And then John's body, of course, was later found right about here. Okay. And let me just ask you something right now, right? So they want us, the prosecution contends and the prosecution witnesses contend. I believe it was Matthew McCabe, Jennifer McCabe, Julie Nagel, Sarah Levinson, Brian Higgins, and 2 other, Caitlin Albert and Tristan Morris. They all drove directly by this spot while it was snowing at like between 1 and 2 in the morning. Every single one of them says that they didn't see a body on the front lawn right there. If you had seen this visual during the trial, would that have made it harder to believe that they could, if a body was there, that they wouldn't have seen it?
Yeah, I mean, it was very interesting because there were no pictures of what the body looked like at the time, right? So nobody took pictures of before they moved the body or moved the patient. We don't know what it really looked like, but looking at that, it's kind of hard to believe you can't see anything. But again, it's hard to say that you couldn't see it, and it's also hard to say that you could. I mean, it's all speculation in that respect, but it'd be hard, somebody who's that large, to not be able to see something there.
Right. So, when we talked before, you said that you were one of 2 jurors who wanted to ask the Judge Cannoni, about whether or not you were, first of all, do you confirm that it was a 12-0 vote for acquittal on murder and leaving the scene of an accident?
That is correct.
And leaving the firm that it was a 12-0 vote for acquittal on murder and leaving the scene of an accident?
That is correct. So that was what the entire group agreed upon.
Okay.
That being said, it was confusing because we didn't have very clear direction on if it was all or nothing. In other words, if all three convictions had to be
Conviction.
100%. So that's why the response that it was that we were continued to need to deliberate because it was not clear on that one charge. So the one charge that we were not very clear on and not everybody was in agreement with was essentially the manslaughter charge, involuntary manslaughter. So that was the one that we were not clear on. But the other two charges, which was essentially second degree murder as well as leaving a scene of an accident, was very clear. We all 12 agreed that was not the case. Right. So,
Right. And when did you guys start voting? So the first day you guys went and deliberated, it was closing arguments, right? And then you had like half a day there to deliberate. And then you came back. I don't know what day of the week it was, but you came back the next day. You had a full day of deliberations. When is the first time you guys took like a tally? And like when you said, okay, did you guys start with that? And did you say like, let's see where we stand right now? Or how'd that work?
I think we wanted to read essentially the first
Yeah, I got that, Brooklyn. He said he said convictions.
day. We kind of took it all in. And after that,
Did you watch the entirety of this interview?
then we started to do a vote. We clearly didn't have a timeline, or I can't recall exactly the exact timeline on when we first decided on some of those essentially convictions. However, it was very clear that each time we made a vote, we wanted to make sure that we read the charges. So
Okay.
very clearly read the charges and understand the charges each time.
So to believe that Karen Reed was not guilty of murder, that means that none of you, even if they thought that she did it for some reason, not a single person on that jury thought that she did it on purpose, correct?
That's what I figured based on what the jury is saying. They're basically, or at least this is me speculating. They are, or at least it sounded like they were of the opinion that it was not intentional.
That is correct.
Okay, so the whole motivation with about the Aruba trip with the Sullivan girls.
Oh
and
my goodness, that was a mess. That was a mess.
she's all angry. So
Yeah.
that didn't really
I
play
forgot
well
about
with
those
you guys.
facts.
That wasn't convincing.
It wasn't convincing. No.
Okay.
And there wasn't enough evidence for one way versus the other, but clearly not enough evidence, or there was doubtful evidence. So
Okay. So you guys were hung on that side.
Yeah, I mean, in essence, it just means that it was not intentional. It's not murder, but they were not. The jury was stuck on the manslaughter, which is completely different.
Second charge. And I believe the count, correct me if I'm wrong, was 6-6, right? For a bit. And you were one of the 6 for not guilty on manslaughter initially, correct?
correct.
And then came the Tui Rodriguez charge. And that's kind of like a, come on, guys, you gotta give it your best shot, get back in there. And then that's when things, what was the atmosphere like in there? Was there bully sessions going on? Was there people trying to urge people that, come on, we got to do this for the O'Keefe family. They deserve some sort of justice. We got to do something. What was it like in there?
It was deliberation. So clearly, one of the things that were happening is we were trying to examine all the evidence and looking into holes for the case, whether on one side versus the other.
Okay.
And ultimately, that's what led to some people swaying in one direction, and then some people remaining and standing their ground. Some people essentially remained and stood their ground the entire time. And I think that was I think it's important to see that in terms of the justice system and having this 12 panel jury. I think it would have been one way or the other if it was left to a very small group or only a few individuals. But given the circumstances that it was left to 12 individuals that have to ultimately come up with the same decision, I think is a very good system as it is.
So what got so it's a couple people changed their mind though. So there must have been some leaders in that room. Have you ever seen the movie 12 Angry Men?
That's a good movie.
Yes.
It's a classic. So obviously in that movie, Henry Fonda is very convincing. He has a strong personality and he's able to sway 11 angry men to come to his side. So surely like the vote was 6-6 and then it went 9-3 for guilty. So I'm guessing there must have been some dominant personalities in that room.
I mean, not so much dominant personality. I guess I'd be interested in finding out what the specific facts are or were that swayed people to vote guilty.
Who would you say that? Would you say the foreman was one of those and an engineer? Is that correct?
I think a lot of people were strong in that room in that they were opinionated, and based on their opinions and their level of expertise and what we were given in terms of evidence, that's how we ultimately arrived at that conclusion, or each individual arrived at that.
Okay, I was going to say you guys didn't come to a conclusion because you hung.
Correct.
And so it was 9-3, and you kind of wavered a little bit, right? Like they convinced you one way, and then like what you told me last time was it was 9-3, and you were kind of on the fence, and then you kind of came back, and there was 8-4. Is that an accurate depiction of what happened? Would you say it ended in 8-4 for guilty to not guilty?
That's correct.
Okay, and you correct me if I'm wrong. You told me that you and one other juror wanted to ask the judge, Judge Cannoni, whether or not you were allowed to acquit on two of the charges and hang on the third, and that the foreman said, no, we're not going to do that. We have to decide on it's all or nothing.
So it was not a question of whether we can acquit. It was a question on, can we make decisions on each individual conviction independently of each other
individual charge
versus so that was the question. It wasn't necessarily
right. So acquittal, conviction. Yeah. So like you
I mean, that's probably where Karen Reed's defense failed her. Okay. I mean, I guess where there I'll have to go back. I'll have to go back to actually when the jury. I mean, I did actually watch it. I don't know if it was live or not, but I do have a video somewhere on this channel. But what I mean by them failing her, at that point when there was an acquittal on the two charges, they should have made sure that those acquittals were actually on the books, and they didn't do that here.
But you wanted to ask the judge, are we allowed to come to a decision on two of the charges and hang on the third? And the foreman said,
here's what I think. I think that acquitted on the murder and leaving the scene, I highly doubt that the Commonwealth would have, pursued charges on the one charge that is hung. I doubt it.
That's not going to happen. No.
And it wasn't necessarily just the Furman, but there was a bunch of other opinionated individuals also kind of saying that, no, I think we have to look at it as a whole as opposed to independent. But clearly the person who was in charge at the time was the foreman. So his word or their word was more pronounced.
So those notes that he would write, were those group efforts, those notes, or like, I mean, they were well written. Obviously, a lot of people have talked about those notes, and the SJC in particular looked at those notes, and he used the word charges plural, and that was a big the SJC cited that a bunch of times. He said that we are deeply divided on the charges, he said, and did you guys come up with that note together, or did he write that himself, or did Chat GPT write it? How did that get written?
It was written by the foreman with in collaboration with all the other jurors. So
Okay.
we all looked at it. We all kind of accepted it as such. Again, it was one of the questions that we wanted to ask the judge was for clarification on can we look at these charges individually? But ultimately, that kind of question was put down, and essentially we had no choice but to just again, based on the group, right, or majority rule, to say that we were just going to ask
I know that's pretty troubling, though. Why? I'm pretty sure usually the jury instructions are for, to consider the charges individually or each charge on its own. So that's a little troubling that the jurors thought that they had to be unanimous on all the charge. I don't know. That's a little troubling.
one question, or it's a all or nothing
Mm.
scenario, as opposed to can be treated individually from each other or independently from
Now,
each other.
a lot of people would say that if they were in that situation and they were not being allowed to talk to the judge, they would say, "Well, too bad. They would make a bigger stink about it. How did you feel about that? I mean, do you feel like after this happened, I mean, do you feel badly for Karen Reed that, that she was acquitted? You were in that room. You guys all voted a bunch of times. And, if you had just known, if it had been communicated to you better, if, you're not, the whole thing was just seemed like you're not professional jurors. That's the way one of the jurors put it, is like, I'm not a professional juror. It's my first time
Nobody's
doing a murder trial.
professional
I don't know
juror.
how this works, but I know we acquitted her, and this seems like a technicality. Do you think Karen Reed got the shaft?
Yeah, I think it's totally unfortunate because we just weren't well informed. And you're right, we're not professional jurors. We don't know how the law works. And it's kind of sad that, or unfortunate that we don't have that kind of view from an individual. So if we're in law, we would know how it's supposed to work. But from somebody who's new to becoming a juror or being a juror, we wouldn't know how the system really works. So it was very unfortunate circumstances.
Yeah. So just random question. I have so many questions, obviously, but one question is, you're obviously of Asian descent. And
What does that have
during
to
the
do with it?
trial, there was one point where they were reading Matt McCabe's text messages out loud, and David Yannetti was cross-examining him, and he was reading them. And Matthew McCabe said something about like the Asian house, and I thought that was I knew there was two Asian members of the jury, and I'm like, I wonder if they did that on purpose. Did that come across to you as at all offensive or anything like that? Him calling it the Asian house next door?
I think borderline kind of. I think it's borderline kind of offensive, but I don't think of it as offensive because I was born and raised here. So I think I looked at it as just somehow a descriptor, but I can see how
Okay.
some people would be offended by that kind of terminology.
Well, I think the defense was hoping you would be offended particularly by that. I think that's why they had him read it, is because he called it the Asian house. And I wasn't in the courtroom for that one because I wasn't allowed to be in there when Matt McCabe
Oh my goodness.
testified. But so I didn't get to see the reactions of the two Asian
Why
members
weren't you allowed
of the
in there,
jury.
turtle boy?
Yeah.
So I wasn't sure if it landed or not. But you were there on obviously the closing day of closing arguments, and Brian Albert, Colin Albert, and Jennifer McCabe walked into court and sat with the O'Keefe family. And
Right.
just the way they were positioned, they were staring directly at you. How did you feel about that?
It was a little intimidating. And I say intimidating, it was just at the end. I think we're all at that point where we want this to have some closure. And I think
Benji, my day has been okay. I did not do very much today. I did not do very much yesterday. which I enjoy because typically I'm running around like a headless chicken. But the reason why I was comfortable not doing anything is because I'm off this week and I'll be doing a lot of, personal work. So yeah, thanks for asking, Benji. I appreciate that. And I appreciate your email as well. Brooklyn says, I cannot see. Okay, so Brooklyn says that they took out a restraining order against Turtle Boy. I know that. I believe. Let me think about it. Something about him being outside their house or something along those lines, if I'm not mistaken.
Was slightly intimidating to see everybody there and all the players there,
Okay.
to some respect. I wouldn't say so much that I was fearful, but intimidated by everybody staring at me, right? So, or looking at me, and I say me, but it really is the group,
14
right? The jury.
Yeah, all 15 of you that were up there
Right.
and sat through 3 months of this, and you didn't get paid. I mean, they didn't really
Was
pay
that
you for
3
this, like
months?
$50 a day or something you got.
Yeah, some small amount, yes.
So you gave up all this time, and God bless you, because it was hot sometimes in
Very
that
curious.
courtroom, and it was a lot of the testimony was incredibly boring. I lived for this shit, and even I was bored by some of it. And I looked, and sometimes jurors were falling asleep because Adam Lally can just put you to sleep sometimes.
Yeah, he was
How
a
do you
painful,
feel about the fact that you
prosecutor.
gave 3 months of your life to this, and ultimately the result was nothing?
What do you mean?
I feel that we kind of failed the system in that we were charged with this responsibility and we came up with certain decisions, but at the end, it was not kind of looked
So
at
there's no
or
resolution.
taken into consideration in terms of some of the charges. And I think that was a failure of the system, and it
That was on the
is a
defense.
disappointment. But that being said, I think it was a very good learning experience to be able to see the justice system.
That was on the defense. I have 3 minutes, folks. 3 minutes, and then I have to go make some food.
I wish that it had worked out for everybody and there was closure all across the board. But right now, there's no closure for the O'Keefe family and for the Reeds, right?
Yeah.
So there's nothing there.
So you are an EMT, which
Hmm.
is such a unique job.
Hmm.
It's particularly for this case.
That's interesting, actually.
And at the scene, the EMTs were the kind of the first people to testify.
Right.
And I think they interviewed like 8 or 9 of them. And 2 of them, no, I apologize. 3 of them testified that they heard Karen Reed say, I did it, I did it, I did it. If you came across a car accident or something like that with a dead body on the road, and there was a woman screaming, I did it, I did it, I did it, would you tell the police what she said? Like then and there, and this woman's confessing to a crime?
Okay, what does he say?
I honestly would focus on taking care of the patient
Okay.
and not necessarily focusing on that individual. That being said, if that individual was my patient, then obviously I would need to disclose that information to law enforcement. But at that time, if my patient was Mr.
It seems like Dr. Turtle Boy is disappointed by that response.
O'Keefe, then I would focus on Mr. O'Keefe and his resuscitation first and foremost.
To be focusing on John O'Keefe's resuscitation. Yeah. So when they got there, they the ambulance got there. They were there for about a couple minutes trying to resuscitate him, and then they immediately put him on a gurney, put him into the ambulance, and got him out of there. And you must have come across fatalities many times, I'm guessing. Must. I mean, God bless you. I don't know how you guys do it, but I'm assuming you've seen too many dead bodies. When that happens, you've come across car accidents, I'm assuming, many times too?
Yes.
Okay. So what is the protocol? Like, what would the protocol in a situation like this be? Do you think that the police and the first responders handled this in a way that you would expect it to be handled?
What's his response?
Like, not as far as not putting crime scene tape up or anything like that?
I don't think it was as coordinated as it should be. And I don't know if that's a fault of necessarily each individual or a problem with the system, in that maybe they didn't have the proper training, or they should have asked more resources to actually make sure that it was done well. But I have to admit, it does not seem like it was done well in any way, shape, or form.
So, are you qualified to look at, like, a person's body after they're deceased and determine cause of
What,
death?
an
Is that something you're
autopsy?
familiar with as an EMT, or is that not something you're trained to do?
That's not my forte. I'm not
It is not.
necessarily, all I know is based on what is provided to me
Mhm.
in terms of evidence, but I'm not in any way, shape, or form a educated person on pathology.
Well, luckily, there
Mhm.
were 2 experts provided by the federal government from a company called ARCA that
Okay.
testified, 2 doctors, and they were the last 2 witnesses to go.
Okay.
And in order to, they both testified that, according to the physics, the science and the physics, the injuries to John O'Keefe are not consistent with being hit by a car, and the damage to the vehicle is not consistent with hitting a pedestrian. And so those guys are, doctors, PhDs, they do this for a living, etc. And in order to find Karen Reed guilty of manslaughter, you have to listen to the ARCA experts and say, I don't believe them.
What's his response?
So how did 8 jurors reach the conclusion that those guys didn't know what they were talking about?
It was as a direct result of the Karen was there at that time,
Okay. Wait, what?
and John was there at the time, and it was believed that John died there, therefore, right, at that location, and therefore it seemed like, and everybody, all the witnesses were suggesting that he was never inside the house,
Okay.
and as a direct result, the
With
assumption,
an
or if you
imprint.
connected the dots based on the evidence that was provided to us, it seemed like there was some sort of collision with the car, and therefore
So what this juror is saying is that it sounds like the jurors actually believed, or at least some of them, 8 of them believed the Alberts and the McCabe's.
or there was damages to the vehicle. And with the damages to the vehicle, and that both individuals were there and present, that the
Circumstantial
cause
evidence.
must have been, or somehow, some sort of involvement by Miss Reed. So that was how they all arrived at.
But how did they reconcile? Was the ARCA testimony brought up by the people that thought that she was not guilty? Did they? I'm sure somebody in that room must have said, but these experts are telling us that that's not possible. And what was the answer to that? Like, did people say that that these guys are bullshit artists, that they're fake doctors? Like, what was the reason not to believe them?
I think the major rebuttal was, we don't know. And that was the other thing. It was very ambiguous on
Ambiguous.
why these individuals were testifying.
Okay.
And so there was a question in the group on their essential integrity, in terms of, were they there
Okay, so it just sounds like they attached little weight or no weight to the defense experts.
as a direct result of somebody else trying to steer us in a different direction and confuse the jury. So it wasn't sure if it was insurance. It wasn't sure if it was, you know, whether the Reeds were doing it, somebody else was doing it, or yourself was doing it to bring
Myself.
this group to try to testify, so that it would sway the jury in one direction or the other. And that, I think that was one of the things that was, again, unfortunate, because I guess it cannot be said, or didn't want to be revealed to us, on what were the circumstances of why those individuals were testifying, other than they were testifying for the defense.
Because now, obviously now that the trial's over, that they're not even defense experts, they're FBI. They were available to both sides, and only the defense called them. And but it seems like the conversation in the room went, and they said some people were suggesting maybe they were the insurance company, of course, because of course an insurance company would benefit from not
Right.
having an automobile collision.
Right.
Obviously, they wouldn't have to pay anything out. Or me? How did people thought I paid the ARCA guys? That's wild.
Like anybody, somebody was trying to, again, to try to sway the jury in one direction versus the other.
I'm not that powerful. I promise you. I can't hire, and I can't afford those guys. But so that's basically the reason that they came up with. They said they heard all their testimony, and then they said, "Nah, those guys are just probably paid off by the insurance company. We're gonna
Okay, I'll give it another 10 minutes. I'm a little too invested. I'll give it another 10 minutes and then I really need to go.
disregard everything that they said."
Yeah, and one of the other reasons is because there was the other testimony of the individual from the dog bite expert and all of the other
Well,
things
that's old bag's favorite old bag's favorite expert.
that the defense was trying to bring up. That again, wasn't sure if it was just to try to confuse.
Okay, it sounds like at least 8 folks on the jury did not find the defense expert witnesses to be credible. This is what it sounds like to me.
Use or sway the jury in one direction versus the other, or create a
And I've said it before. I forgot the expert's name, but the dog bite expert. To me, she's not a credible witness. But I've said it before. It does not matter the fact. It does not matter that I find her not to be credible. It does not matter that, um, you know, her what is this? Her method is not based on anything, not peer reviewed, and that she apparently took everything out of her head or whatever. That does not matter because as far as the defense is concerned, their real, apart from securing the defendant's constitutional rights, it's to really muddy the water. So that's why it does not matter that I don't find her credible, but her testifying could potentially sway jurors one way or another.
a jury which was created reasonable doubt, and therefore
There we
the
go,
vote
Dr.
had to be in
Russell.
one direction
Thank you
versus
for
the other.
So some of
That's probably the third or second time that you've told me I'm not good with names.
it sounds like what you're saying is that some of the jurors in the room were saying that all of this defense third party culprit thing, a dog biting John, this is all bullshit. This is all a smokescreen, and all these people, these this dog bite expert they're bringing in, this is all a distraction from the fact that Karen Reed ran John over. Is that an accurate portrayal of what people were saying in that room?
That is correct.
Wow. Okay. So in order to believe that Karen Reed killed John O'Keefe, you have to believe that, and that John O'Keefe didn't go inside the house. You have to believe all of the McAlberts who testified. And so am I correct in saying that they found the McAlberts to be convincing witnesses and truth tellers?
Correct. And
I mean,
and
that's not completely inconceivable. I think that would only make sense to somebody that is steadfast on Karen Reed, being acquitted. But other than that, I mean, they are a little problematic. But what's up, Fever, Mr. Fever from New York? Okay, Fever says, "What's this case about? Corrupt lawyers." No, this is the Karen retrial. Retrial, right? Initially she went on trial. My years are a blur, but I think it was 2024. She was accused of, killing her boyfriend, who I believe O'Keefe was an officer. There was a hung jury, and she goes back to trial April 1st. So I was just coming up here because if I don't come up here, I'm gonna disappear. I won't be live tomorrow. Yeah, tomorrow's Monday. So Monday I won't be live, but I will be live on Tuesday, and then we're going to get started with the one trial that I think everybody should have watched in 2025.
I will say that that's to.
Are you having a good weekend, Fever? What's going on?
some respect.
What
To
did he
be
say?
convincing witnesses and truth tellers.
Correct. And I will say that that's to some respect, not not only to say it's correct, but also to some respect, because there were some individuals who just looked at the facts. Again, the
Okay.
clear fact that Karen was operating a vehicle
So less on
and
credibility then.
drove the vehicle to that location, 34 Fairview.
Mhm.
And then ultimately, John O'Keefe lay at rest and died on essentially that address. And so
Eva, did you have to work today or were you off?
everybody else is saying that he never entered the premises. Therefore, she must be at fault because he clearly did not just injure himself there. So
Okay.
Did anybody suggest that maybe the McAlberts are not being truthful? That maybe he did go inside? I assume somebody in the room, the not guilty voters, must have said that these people are lying, obviously. And what did people say to that? I mean, did some people believe at least that they weren't being honest?
I think the individuals who believe that she was not guilty was because of the mere fact that it was not adding up. So the injuries to John O'Keefe
Okay.
ultimately did not add up to the damage to the vehicle.
Mhm.
And what ultimately injured him was, or led to his death, was a
What kind of music were you listening to, Fever? That's what I did on Friday night. That's what I did. And then yesterday I did that. I worked a little bit yesterday though, but not too many hours. I listened to some really good music again. I was playing Coldplay. I listened to Radiohead. Uh we went to Walmart a little bit. When we go to Walmart, I play music with no cuss words, or at least with my kids in the car. So around that time we listened to Janet Jackson. I loved Janet Jackson when I was younger, okay? And so I have my kid listen to Janet Jackson. Some of the songs are a little off. But we listened to a little bit of Janet Jackson. What else did we listen to? I don't remember. But I listened mostly to Coldplay and Radiohead, and I listened to Linkin Park as well. So yeah, okay. So Fever said it's his day off. All right. So always ask for Sunday off. It's a good day to recoup.
injury to his head, which was not very clear that that type of damage could have occurred on the vehicle. And there was no damages on the vehicle that would indicate that kind of situation. So for
Yeah,
those who were skeptical, that's what they were looking at.
yeah, the Commonwealth alleges that that his arm, I still can't believe they said this theory, that the arm was out and that the arm is what caused the taillight basically acted as a knife and just sliced his arm up and then caused him to spin and then land 30 feet on the grass. And the gash in the back of the head came from hitting the grass, which they said was so hard that it somehow caused a gash in the back of his head. People really believe that?
Yeah, I mean, I don't think
Yeah, I do. I enjoy a little rock and roll. And then okay. All right.
a lot of people in the room.
What did he say?
Yeah, I mean, I don't think a lot of people in the room. Some people who were experts in science,
Okay.
right, and physics, or have some knowledge of physics, necessarily believe that as the case, given the circumstances, that it was not very.
I mean, what's concerning, I mean, this is this one juror's interpretation of the deliberations. But based on what he's saying, what is concerning to me is that folks were employing their so-called expertise as opposed to just focusing on what the prosecution presented. So that's the one aspect that is it's kind of concerning.
Clear.
Mhm.
But again, some individuals just believed at the just the circumstance that Karen and John were there at the same time, and John ultimately was killed.
Okay.
And the text stream data is what you mentioned to me a lot last time, and you said that that was what the guilty people really stuck to was the text stream data. What was so convincing about the text stream data for them?
It was a combination of the speed, and suddenly there's an increase in speed and a decrease in speed, consistent with maybe somebody backing up. And so that looking at that was kind of convincing that she must have accelerated in a backwards motion. And then
even though that 24 miles an hour in reverse 62 feet thing, there was no time associated with that. It was measured in what's called key cycles, and they couldn't explain, like, at least they didn't say for sure, like, this happened at 12:32. For all we know, that event could have happened at another time or another place, because they didn't give us a time. But people were pretty convinced just based on that alone that, yeah, that's proof positive that it happened at that exact same time.
See, what else did they say?
I think it was a combination of, again, the circumstance that both individuals were there. There's evidence of a broken tail light, the injury to John, and the injuries that John sustained. And then ultimately, that texting data was just another piece that indicated, yes, there must have been some movement. It was very interesting, though it wasn't very clear. And I think I said this last time, that it would have been nice to have somebody who is an expert in that, or somebody who has knowledge of that type of data from that company, right? From Lexus or whatever company, right? And to provide some information on if that can be accurate and what causes it to actually occur. So, for example, like I was saying, or I was thinking, like right now, as I'm driving home, right? My car could have slipped, and that could have triggered.
Fiva, so this case will only begin in April. That gives me enough time to, create, just a little short video. I guess bring everybody up to speed. Brooklyn says, "So did you follow along on the Zachary Hughes case?" I watched a little bit of that case. I watched him testify. I watched him take the stand. After he was convicted, I watched his father's mitigating statement where the father called him a good boy, talked about his skills as what instrument did he play? Was it the piano? Something about, him entertaining wealthy folks and the like, and his son being a hero. So yeah, I watched I watched a little bit of that. Brooklyn said, why did he take the stand? He probably took the stand against his attorney's advice. But let me think. What was Zach's defense? Let me see. Hold on. Because there are certain defenses where a defendant actually has to take the stand in order to invoke that defense. It's not always the case. Okay. I don't know. Yeah, because again, the defense argued that, Zach took Christina's life because he believed that it was a just cause. Here's the thing, though, Brooklyn. What I do spend a lot of time on Reddit. On Reddit, from my understanding, there was a juror interviewed post conviction. And the juror was of the opinion that they were misled in that they were not made aware of all the facts. And those facts being, all the essay allegations that supposedly led Zach to engage in the conduct that he was convicted of. Okay. So they apparently wanted to have all the facts. Maybe they would have acquitted. I don't know. Brooklyn says he is a graduate of Juilliard School of Music in Lincoln. The man was talented, but that does not, that's only one part of, of his life, I suppose.
There's something, right, to suggest.
Yeah, but in my view, it probably would have made a difference if the essay allegations were brought to the forefront. That would have made a difference as far as the verdict is concerned. But then there's this whole thing of, vigilante justice. Okay, they're not everybody's going to go for that, and that's also going to be a challenge for Luigi Mangione. Again, I still think that's a good defense case. Okay, that's a good defense case, but we should not undermine an unbiased jury. All right, because if the here's the thing with juries, you really don't select. Okay, you deselect. You're left with whatever you're left with. But if if the jury in that Luigi Mangione case is truly impartial, he's getting convicted. If the jury is truly impartial, he is going to get convicted. But if the defense, I don't know, if somehow they, get somebody to slip on that jury, that, ties things up, then it's just, I don't even know what kind of defense they can raise. I mean, the last time I checked, I believe they're going with the insanity defense, unless they change it now. This trial's probably Luigi Mangione is probably going to go to trial in about 2 years, maybe longer. Okay, but the last time I checked, they were going with insanity. They were pleading insanity. Okay, my biggest thing, I don't know. That's Luigi Mangione is tricky, but it's not as tricky as the Idaho case. That Idaho case, every time I think about it, I just want to throw up because it's that difficult. Um, Brooklyn says they need to find 36 jurors for 3 cases. Impossible to find them. What do you mean it's impossible? This is New York City that almost has 10 million people. That's not impossible. The other case is in what's a place? Somewhere in Philadelphia, Altoona, whatever the place is. I think that's the name of the city. So that's not impossible. That's a drop. Okay. Even for New York City, that's a drop. You have to think that Donald Trump, who was once upon a time president, they found a jury for him and they found an impartial jury and they convicted. So, and I mean, okay, upstate is obviously different from the city itself, but even for New York City itself, not everybody, I mean, Brooklyn, you're an example. Not every single person that lives in the city is liberal or Democrat or, uh, anything between. Some folks are Republicans, and that's just how it is. So, but again, do not undermine the power of an impartial jury. So, yeah, that's where we are. But the Luigi Mangione case, I think that is for sure one case where jury nullification, we could see it happen in that case. But again, if they focus, it's this whole thing, and Fiva is agreeing with me. That's the thing. Jury nullification is a sure possibility in the Luigi Mangione case. But again, we're not going to undermine the workings of an impartial jury because the facts in that case kind of, they yeah, they're not favorable. They're not favorable to the defense. The only way I see out as far as the defense is concerned, it's going to be motions and hoping that law enforcement violated Luigi's rights in one way or another, in one manner or another. Because if everything is not favorable, because if they did everything by the books and nothing is out, then all that evidence is going to come in. And there are people out there that just do not focus on the news. I'm not one of those people because typically I know anything and everything that's going on in the news, especially when it's related to law and crime. But there are just some people out there that just don't pay attention to the news. My sister's one of those people. She apparently chooses to focus on the positive. So she's not going to watch things that are going to, you know, I guess bring her down. So there are some people out there that just don't pay attention to the news. So there are some people out there that probably do not even know about this Luigi Mangione case, and they might just live in New York City, and they're people without social media. Like I don't have real social media outside of YouTube and Reddit. Okay, so Benji was also thinking jury nullification. Right, that's why I keep saying the Luigi Mangione case from that perspective, from the lens of jury nullification, it, you know, it makes a good defense case, but that's not the only aspect. Because again, when I need to charge, hold on, let me plug up my let me plug up my MacBook because it's about to go off. Let me just plug it up quickly. Okay, so that's the one side to the Luigi Mangione case that's or the one aspect that's favorable to the defense. But if they truly get jurors out there that know nothing about the Luigi Mangione case, they're not going to consider him as some type of hero. Okay, and here's the other thing as well. If the jury ends up with some, I mean, this is Manhattan too. So if they end up with some folks on there that have money or people that don't have real struggles, they will not be able to relate to Luigi Mangione. They'll find it unacceptable for an individual to take matters into their own hands, regardless of, you know, how people view the healthcare system. So some folks might not take lightly of his or at least the allegations against him. Uh okay, so Fever says facts is facts, wrong is wrong, but it doesn't matter in certain states or even certain countries. Benji says, is it possible for the defense to play into that, as in play their card in order to cause jury nullification? I think that's probably defense only avenue here. I don't see anything else. And the reason why it's the only avenue, initially they were not going to accept money from this legal fund, because if I'm not mistaken, I believe it was over $300,000 that was raised by this legal fund. Okay, believe it was over $300,000. Initially, they said they were not going to take any of that money. They're not going to, dip into it. And then, sure enough, they did. They did, and then they ended up, somebody created a website. Okay, Karen. Friedman Agnifilo referred to it, so it sounds like she's aware of the website. I do not know if she played a role in getting it set up, but she's aware of it, and apparently they post to it. So I think that is part of it. That's another extension into this. And that's also, again, because I do not know Karen Friedman Agnifilo personally, but the few times that she has come on out and addressed the press, she really did not say anything. And that's what I liked about her approach, because I don't like it when defense attorneys, public defenders are in the media talking about cases that have not resolved. Okay, I just don't like it, because you could say things that things can go wrong, and things do go wrong. Okay, but again, on Friday when I saw her approach the press and actually talk, I'm like, okay, what is this? But then within about 2 minutes, maybe 30 seconds, it clicked. I'm like, okay, this man has a lot of support. He has a lot of fans, supporters. People are paying for the for his legal fees. So it would make sense that they would like to not necessarily appease, but maybe loop people in, have them follow what the proceedings were in court. And then Fiva says, okay, When you say you put two and two together, what did you put together, Fever? Brooklyn says that I don't think they can go for capital punishment. There's no capital punishment in New York. That is federal, though. Federal, I do not know that he can escape that. So, yeah, as far as New York State, my recollection, there's no, yeah, the death penalty is not on the table. You get life because I think, let me think. Murder one, I think it's 25 to life, if I'm not mistaken. I've not looked at that stuff in a while, but I think it's 25. Yeah, class one felony. Yeah, I think that's 25 to life. There's no death penalty in New York State. Let's see. Any other inputs? I'm here much longer. Oh my goodness, girl. It's like 8:30. I need to go, you guys. I need to go. Yeah, so tomorrow, Monday, I will not be live. I just need to again, Monday I'm gonna have to fix. I'm gonna be doing some things in the background. And then Tuesday, we are gonna go live. We're gonna start with the one case that I think everybody should watch or should have watched in 2025. So that's what we're gonna start with. I have to figure out what time though, because around Zeta took my phone, but it's around. I have a CLE. CLE is continuing legal education on the federal. So what is this? Sentencing guidelines. I do not remember if it starts at 12 to 1. Is it 12 to 1 or is it 1 to 2? One of those two times. So we're going to start. Yeah, that's what. Okay, now I'm thinking because I have to schedule the live tomorrow. Okay, so on Tuesday, we are going to start early. I'm sorry, Benji. You're going to have to join the replay. So on Tuesday, we are going to start early, but we are going to take a break for maybe an hour or an hour and a half. Okay, we're going to take a break for an hour and a half because I want to get through this trial. I think it's best we get through the trial before while I'm still on my vacation. It's not a real vacation, but while I'm off. I think we want to get through the trial. It might take us longer though, because I think the trial was at least 2 weeks. Okay, I'll schedule it. I'll just have to find a time. Not too early, but I'm gonna have to find a time. Anyways, I'll think about those things. You guys have a fantastic Monday. We will reconvene on Tuesday. Okay. All right. Thanks for tuning in. I'll continue watching this interview, this Turtle Boy interview, because the juror does raise, it kind of raises a few concerns. I don't have the same concerns as the folks in the comments here, because I mean, most of the people that are watching these what is this, these interviews, I presume, are Karen Reed fans. And I know Brooklyn is a Karen Reed fan. I prefer to be neutral, but he said at least one thing that I found very concerning, and that thing being, these so-called no, let me not say so-called people basically tapping into their expertise or tapping into their own jobs or experiences in order to reach a verdict. To me, that is a little it's a little concerning. But the other concern that I have, it sounds as though they were not properly instructed, or at least maybe they misinterpreted the instructions, but something got lost in translation. In any event, folks, let me go. I'm up here much longer than I should be. So I'll see you guys on Tuesday. All right. Have a good night.